Let's then stay with the story and speak to Advocate Romeo Nthambeleni, who's a legal analyst, and get his sense on the proceedings. Advocate Nthambeleni, thank you so much for your time this afternoon. I mean, Karyn Maughan argues that the former president has not obtained a nolle prosequi certificate from the Director of Public Prosecutions to institute a private prosecution against her. How much of a hurdle could this be when it comes to getting things started here? Advocate Nthambeleni, I'm not sure if you're able to hear me.
I can hear you, Bongiwe. Can you hear me?
Yes, now I can hear you. Thank you so much. I'm not sure if you heard the question.
Yeah, I did.
Oh, yes, please respond.
Yeah, good afternoon to you, Bongiwe, and the viewers. Look, in South Africa, the South African Criminal Procedure Act talks about two instances where one can bring private prosecution. That is under Section 7 and Section 8. When under Section 7 is where the NPA has actually issued what we refer to as the certificate nolle prosequi that you are actually referring to. And that certificate is important, Bongiwe, because without that certificate, you are not going to be able to proceed and proceed with private prosecution. So there is a point in that statement that is being made, although it might be seen as a technical legal argument that when the NPA has not issued that certificate, you are not going to be able to proceed with prosecuting on a private prosecution. So those are two instances under Section 7 and Section 8 under the statutory interpretation of the Criminal Procedure Act, where it gives you an instance of bringing private prosecution.
So how does then this play out going forward then when we look at this? Because I remember, when you think about the Jiba matter, for example, where AfriForum wanted a certificate, we then saw them bringing an application to try and force the hand of the NPA in this regard. So how do you see this one playing out in this particular matter?
Yeah, I think the same pattern will actually follow, because the argument that Karyn is actually bringing might actually find favor in court, because how are you going to prosecute her without a proper certificate being issued by the NPA? So I think they will insist that the NPA must issue a certificate nolle prosequi, and then if that then is issued, then they can be able to proceed with the private prosecution. That is very much important. That argument actually holds water and is going to actually stand, because without that, you are not going to be able to actually proceed. But in the matter of Downer, on the other instance, indeed there was a certificate nolle prosequi that was issued by the NPA, hence that the matter is actually likely to actually proceed. And we see that there is a postponement on both matters to be somewhere in February next year. And in the matter of Karyn, there's still the applications that are supposed to be had that deals with the very, very issue that we are talking about, to ventilate this issue of the certificate.
So could we then see, let's say maybe they succeed in getting the certificate, could we see this matter, being joined together with that of Advocate Billy Downer, or should they not be able then to get certificate? Of course, it could be even a long period of time before we could potentially see how things unfold here.
No, yeah, you're correct. If they are successful in securing that certificate nolle prosequi, they can bring an application for joinder of the matters for them to be held simultaneously at the very same time. And then, if there are no appeals in the matter, and if, let's say, Karyn is not successful in the application that she's actually going to bring, which is going to be held in December, and then, given the nature of these proceedings, we have seen that matters get appealed up until the Constitutional Court. I had the former speaker now speaking about the delaying tactics and stalling grind, and that was just the pot calling the kettle black, because in their proceedings there are also matters that are actually postponed on a technical basis. So Karyn has the right to actually exhaust all available remedies that are at her disposal before the matter actually is heard in court.
Now, the former president, also argues that the application by Karyn Maughan, in which way she seeks to stop the private prosecution, he says that it's designed to delay what he calls her inevitable prosecution. And listening to what you're saying, and of course, and the former speaker, the spokesperson for the Jacob Zuma Foundation, and going through the papers, how much of a strong case, though, does the former president have here, looking at, what we are seeing before us and before the courts currently?
Look, the prospects of success in any matter are dependent on the merits of the matter. And insofar as I'm concerned, the matter turns on the interpretation of the Constitution, Section 16, and also its interpretation on the right for the media to actually report without favor, without fear, and without prejudice, balanced against the individual rights of an individual who. This individual that we're actually speaking about is not an ordinary individual. He's a former president, and the public has actually the right to know. There was a decision that was in the Constitutional Court which dealt with the issues relating to SARS and also the information relating to the tax affairs of the former president being actually made public. So the test is very different, Bongiwe, when you deal with a person who was a public figure who was a president, as opposed to ordinary citizens like you and me. So the hurdle is much more higher on the side of the president to actually prove that there was breach of the law in relation to what Karyn has actually done in terms of her duty to actually report to the public and what was actually reported and the content of the letter as well.
And the former president at the same time arguing that he has the right to prosecute Maughan and say, and I'm quoting some of what he says. He says, in doing so, I do not seek to stop her from reporting about my trial. I wish to prevent her from committing a crime with the NPA officials, to my personal prejudice, etc., etc. But does this case not change how she, and that is Karyn Maughan, of course, how she's going to be reporting on this particular matter going forward, and also looking at the papers and how he is suggesting that there may have been an antagonistic relationship even in her reporting?
Yeah, look, what you're saying, we have seen what is actually transpiring on Twitter and the way in which Karyn is being lynched in the Twitter streets in relation to the very similar matter. So that forms a very strong argument for Karyn in terms of reporting and victimization, in terms of how she actually reports the matter going forward. And while she's being vilified, doing her work as a journalist, is the court going to look at that and ignore it? I don't think so. So that is actually going to be balanced against the individual rights as to which one outweighs the other. And as I've already said, the Constitutional Court has already made a ruling in that regard, and we can already see where it's actually going. So we saw what is actually happening on Twitter, and how Karyn is being branded as this kind of a person who has done an irresponsible thing of actually leaking a document that was actually supposed to be confidential. So that is very, very key and is important. All
right, Advocate Nthambeleni, always a pleasure to speak to you. Thank you so much for your time. That's Advocate Romeo Nthambeleni, a legal analyst, as we're looking at the case, of course, that was postponed in the High Court in Pietermaritzburg, and that is the private prosecution by former President Jacob Zuma against Advocate Billy Downer and journalist Karyn Maughan.